Welcome back. Tonight, you're focusing on matters of judicial independence. We have seen the tension between the executive and the judiciary, something that has seen Chief Justice David Maraga complain and lament time and over again. We are having Mr. Patrick Gonjiri, who is the Vice Chair of the International Commission on Jurists here in Kenya, and he's also an advocate in the High Court of Kenya. He also doubles as a managing partner at Plus Law Advocates. Welcome, Mr. Gonjiri.
Thank you very much, Irene, and thank you for having me on the program.
All right. So we have seen some sort of tension between the judiciary and the executive, something that has started for some time now. But the way things are turning out, it seems there is more than meets the eye. Why are we having this sort of tussle between the two arms of government, yet they're both independent of government?
Thank you very much, Erin. I think, yes, there's tension between the judiciary and the executive on the other hand. And I think one of the bases for this tension can be traced to how bold the judiciary has been in interpreting the Constitution. Sometimes the judiciary has come up with far-reaching judgments that are per the Constitution very correct, but politically the judgments are not correct, so to speak. Yeah. And I have in mind landmark judgments like the 2017 presidential elections, when the Supreme Court nullified the presidential election. Mm-hmm. And then if we can learn from the reaction from the president and those senior politicians in Jubilee government, they were saying that they have accepted the verdict, but warned very sternly that they will revisit. Mm-hmm. So it can be said that this has been part of what is causing the tension between the judiciary and the president and the executive. And from 2017, we have seen sustained attacks on the persons in the judiciary. We have seen a reduction of funds. We have seen deliberate reduction of the budgetary allocation to the judiciary. And we have seen blatant violation of court orders by very senior government officials. So that, in my view, is the basis of this tension.
Mm-hmm. All right. Yeah. We have seen some sort of social media propaganda, let me call it that, of course, portraying the Chief Justice, David Maraga, in some type of way. But we have not seen any criminal actions being taken. Recently, we had a woman who came out to say that the Chief Justice is a deadbeat dad, which, of course, paints the judiciary in not it's not a very good picture. Perhaps why are we seeing laxity in terms of addressing some of this propaganda that are being outright there for the common mwananchi to see?
I think this is a continuation of attempts to undermine the judiciary. Mm-hmm. By having personalized attack on the persons of the Chief Justice, having banners placed all over the major roads in the Republic. Some damaging viral videos also making rounds in the social media. And of course, there's a case that was filed earlier this week in Mirimani Children's Court. Yeah. So even the social media has been used adversely to malign the name of the judges, individual judges, and also the senior judges, and also the Chief Justice himself. Mm-hmm. So it is part of the continuation of these intimidation and character assassination of the persons of the person of the Chief Justice, perhaps gears to having him throw in the towel and resign. Mm-hmm. So what we need to see is the persons who are putting up these posters, the persons who are distributing these damaging videos. We need the Commissioner General of Police to take action and to have them laid in court for the appropriate criminal offenses. So we have seen no attempt on the part of the police and the DCI to even investigate the matter and also to bring the culprits into book. And therefore, this leaves the Honorable Chief Justice and the judges very exposed.
Mm-hmm. There are, of course, a lot of issues that Chief Justice David Maraga has raised, which include the issue of budgeting. time and again, we have seen in the three arms of government, judiciary has sort of been receiving little budget, so to speak. Why is this the case? Yet it is an independent arm of government which should have some sort of a basis of a budget. Why are we having this disparity?
For the judiciary to effectively discharge its obligation of the Constitution, first of all, it has to be independent as an institution itself. And in order to guarantee this independence, it has to be adequately resourced. And that is the objective of the framers of the Constitution. When they established what we call the Judiciary Fund. Judiciary Fund is meant to ensure that resources that are due to the judiciary have been timelessly been sent over from the consolidated fund to the judiciary, so that it is able to discharge its function under the Constitution with adequate financial resources. But this has not been the case. If you have listened to CJ Maraga in one of his press conferences, he has chronicled how the judiciary budget has been stagnated or reduced from 2013-2014. 2013-2014, the judiciary received about 0.99% of the national budget. That is the highest that they have received. To date, this financial year, the judiciary received about 0.67% of the national budget. 2.7 billion of that is meant for construction works in the courts and development votes. The rest is recurrent expenditure. So as this is happening, we have not seen commensurate reduction of the budget of the Parliamentary Service Commission, as well as the budget for the Public Service Commission, which are the other commissions in the three arms of government. So there is a very, very deliberate attempt to make sure that funds due to the judiciary are reduced. And if it is reduced, then the judges and the magistrates and the judicial officers and the entire judiciary as a whole will not be able to discharge its functions under the Constitution. Last year, there's something called the State of Judiciary Report, the Soldier Report 2019-2019. It is very clear. It says that the judiciary currently, in the reporting year 2019-2020, is operating under 55% of its human resource capacity. 55% of its human resource capacity. So it is not only judges, it is also other judicial staff that has been reduced. And therefore, if an institution is operating at 55% of its human resource capacity, then it is not able to discharge its functions. And that is why fingers will be pointed that you are the weakest link. Yeah. You are not getting convictions. You are not getting. You are not delivering.
All right. So, what can be the solution to the issue of underfunding in the judiciary, so that moving forward we are not foreseeing a situation like this? Issues being done to undermine the judiciary. What are some of the solutions to the issue of underfunding?
The ultimate solution to this recurring problem is fully operationalizing the judiciary fund. Yes, we have the registration in place, we have the regulations in place, but we have a very huge predicament because the registration that establishes the judiciary fund is predicated on the Public Finance Management Act. It therefore means that even if we are saying that this fund is operational, it has to rely on the Treasury, it has to rely on the Cabinet, National Treasury for it to be fully operational. Yeah. And very many the registrar of the judiciary has to seek very many consents, including consents from the National Treasury, to establish that fund. So this is something that we need to do away with. And for us to fully have the judiciary financially independent, we need to have amendments to the Constitution so that 2.5% of the national budget every financial year is credited to the judiciary fund. This way we'll see a guaranteed income and resources from the national government to the judiciary so that it is able to discharge its functions without having this agitation and all the time craving that money has not been sent to the judiciary. So we need this to be ring-fenced in the Constitution, the 2.5%, which is the internationally accepted standard to be ring-fenced in the Constitution, and this will stop the back and forth between the executive and the judiciary.
All right, Mr. Gunjiri,
Yes.
let us now move to the issue of the appointment of the 41 judges. It is assumed that the president's role in that particular process is just to rubber stamp, but we are foreseeing a delay that is affecting the duty of the judiciary. Why are we foreseeing this delay, yet the role of the president is just to rubber stamp the people who have been appointed by the JSC?
Well, from where I sit, I do not think that the president's role in the appointment of judges is to rubber stamp. Why do I say this?
Right.
I say this because the president is involved in the whole process of recruitment of judges. He is not involved directly. He has two appointees that he has appointed as members of the Judicial Service Commission as per the Constitution. In addition to those two appointees, he has the Honorable Attorney General who sits in that in the Judicial Service Commission to represent the interests of the executive. Number four, we also have a representative of the Public Service Commission sitting in that Judicial Service Commission.
Yes.
So these are, the president is involved in the recruitment of judges through this representative, four of them, if, so to speak.
Yeah.
So once the recommendations have been made, and I think this is now your point, yeah. Once the Judicial Service Commission has gone through the recruitment process and has submitted the names to the president, at that point in time, the president's role is just to appoint. And he does so in his capacity as the head of state. So he has been involved throughout the process, from advertising, from interviewing, from recruiting, all the way to the submission of the names through his representatives. Yes. So if his representatives do not do the job as per his expectations, then he has a recourse of firing them if the law so provides. But where we are now in regard to the appointment of the 41 judges, I think the horses have already left the barn. The law provides, the Judicial Service Act provides that what is remaining now is for the president to formally appoint the 41 would-be judges and swear them into office. There is no, the law does not provide any avenue for revetting of the judges. You can only, there's no avenue for revetting. They cannot be taken back through the process, even if you find that something is wrong with them. So you can only, a candidate can only withdraw voluntarily or become incapacitated or passes on. Those are the only three avenues that the process can be revisited. But it is not open to the president at this point in time to say that, oh, I have realized that some judges are tainted. Remember, 9 of those judges are also, 41 judges are serving in the Court of Appeal. And there's a very elaborate mechanism for removal of judges from the office. So if you are saying a candidate X who is being recommended for appointment in the Court of Appeal has issues, the only way that you can discipline or you can rectify that anomaly is to appoint a tribunal to investigate the merit and demerits of the complaints that have been made. And once the tribunal has returned its verdict, say that this person is suitable or not suitable, then you have no option but to accept. But for now, the horses have left the barn. The president must appoint the 41 judges, and the courts have decreed that in the case of Adrian Jenga versus the Honorable Attorney General, in which case there is no stay of execution of that judgment. So it is incumbent upon the president to uphold the Constitution, to uphold his oath of office, and to swear the 41 judges.
All right. Yes. There have been speculations, or there have been claims by the Law Society of Kenya that Attorney General Paul Kihara has been misadvising the president. You are an advocate of the High Court of Kenya. You have seen this. Do you, of course, read from the same school of thought?
We are reading from the same school of thought with the LSK president and his council, because if you critically look at the conduct of the Honorable Attorney General, as far as the appointment of these judges is concerned, then you'll find a state officer who is not carrying his duty in accordance with the Constitution. I'll take you back to 2017, before the appointment of the 41 judges. the Judicial Service Commission was now then at that point in time, was carrying out a needs assessment.
Yeah.
And the Court of Appeal, led by none other than retired Justice Kariuki, our Honorable Attorney General, wrote back to the JSC and told them, we need you to immediately appoint 6 judges, because the court presently was understaffed. The same Attorney General sat in the Judicial Service Commission that recruited, then as the Attorney General. He sat in the Judicial Service Commission that recruited the judges, and again was party to the appointment and recommendation to the president that the 41 judges, including those ones that were going to the Court of Appeal, are fit for appointment. Right. So at what point in time did he change his view to say that these guys are tainted? So you don't find consistency in his conduct. He has not honestly discharged his mandate under Chapter 6 of the Constitution as required by the Constitution. And in that regard, that is why the president of the Law Society of Kenya, Nelson Harvey, has said that he has not properly advised the president, a position that all the lawyers support.
Perhaps we have seen the executive time and again defy court orders, orders being given by the court or the High Court or the Court of Appeal. We have seen the executive being defiant in obeying some of those court orders. What is the resolution, or what is the way forward concerning that? Because it now seems that it is normal for the executive to defy court orders.
It is actually a disease that senior government officials are not obeying court orders, and this is problematic. And it is not just court orders, even decrees that have been issued against the government, and these decrees concern various number of people. Perhaps some of them were involved in accident, and the courts decreed that they should be paid. But the government has continuously disregarded these court orders. So the solution, again, still lies with the law. So that I have seen some judgments that have emanated from courts that if you, as a public officer, have defied a court order, you will not be saying that it is government that is not obeying the court order. We need to enhance the principle of personal responsibility, so that if a certain minister is obeying a court order, then the minister should be taken liable as a person instead of this big body that is called government. Yeah. Number 2, the president of the Law Society of Kenya has called upon, and this is a position that we are also supporting, that everybody who has a court order that has not been obeyed should furnish it immediately to the Law Society of Kenya, so that there will be agitation around this, so that we can also name and shame the ministers and government officers who are not, or who are deliberately refusing to obey the Constitution and the court order, and just going against their oath of office.
Okay, so now let us now focus on Chief Justice Dan Maraga and looking into how he should move moving forward. We have seen that he is a man clearly under duress, and we have seen him facing challenges from his personal life to his conduct in the office of being the Chief Justice of Kenya. So how should he navigate these murky waters around him?
The Chief Justice has no option but just to remain truthful to his oath of office and uphold the Constitution. Because the Constitution says the judicial authority is exercised for and on behalf of the people of Kenya. So he has to adhere to the Constitution, fidelity to the law and his oath of office, and to ensure that he discharges his functions as he has been doing in the past without fear or favor, because he has no option. He has had an impeccable career in the legal profession as a practitioner of law in Nakuru, and now and serving as a judge of the High Court of Kenya and also in the Court of Appeal. So what we can do is to continue as ICJ Kenya to support him and other civil society movements to ensure that we are there to support the rule of law, to support the CJ when he is being crucified for defending the Constitution and also for defending his oath of office. So he should not back down. He should continue with the same trend that he's on the right path, so to speak. Yeah.
So finally, because we are pressed on time, what can be your parting shot, and of course, saying what are some of the things that you've done as International Commission on Juries in terms of advocating for judicial independence as we wind up?
ICJ Kenya has we have been in existence for about 60 years. We are the oldest human rights organization in the Republic of Kenya. And judicial independence is at the heart of what we do. We have continued to work very, very closely with the Office of the Chief Justice, with the Judiciary, with the Judicial Training Institutes, building their capacity. We have also continued at the grassroots level to work with paralegals. These are persons who are lay people, meaning they're not lawyers, but we help a lot in the administrative of justice and also to build their capacity to sit in the court users committees in Kitui, in Eldoret, in Nyeri, in Laikipia, so as to be able to inform and help the citizenry because we continuously train them. We also, international level, we have been supporting the East African Magistrates and Judges Association. We have participated in their conferences. Last year, we helped IMJA to come up with a sexual harassment policy for the organization. We work closely with the Kenya Women Judges Association in matters that are related to justice, especially access to justice.
All right, so thank you, Mr. Patrick Gonjiri, for giving us an insight, of course, on matters judicial independence and what we are seeing between the executive and the judiciary.
Thank you very much, Irene, and it was a pleasure having you, participating in your program. Right. Thank you.
That has been Mr. Patrick Gonjiri. He's the Vice Chair of the International Commission of Juries here in Kenya and also our advocate in the High Court of Kenya, as well as a managing partner in Plus Law Advocates, of course, giving us a perspective on what is happening between the executive and the judiciary, why we are having this tension, and what should be done to ensure that the two independent arms of government work interdependently. We're taking a short break, but once we return, we'll be returning with more. Do stay tuned.